My best wishes to all. I am Dr. D. Bhuvaneshwari, Assistant Professor, Selection Grade, HOD Department of International Law and Organization, the Tamil Nadu Dr. Ambedkar Law University, Chennai. In this brief lecture, I would like to throw light on essential principles of transfer of property. The Tranfer of Property Act was passed in the year 1882. Let us first look into the purpose, scope, object and scheme of the Act. The purpose of the Act is clearly explained in the preamble as the law relates to the transfer of property by act of parties. The scope and object of the Act has been clearly explained by Whiteley Stokes, a member of Third Law Commission, that the chief objects of the Transfer of Property Act are to bring the rules that regulate the transmission of property between living persons in harmony with the rules affecting its devolution upon death of individual, so as to complement the work commenced in framing the law of intestate and testament succession. Second object is to complete the Code of Contract Law as it relates to immovable property. The scheme of the Act clearly states Transfer of Property Act contains two parts, Part 1 and Part 2. The first part deals with the general principles of transfer. The second part deals with specific transfers like sales, mortgages, leases, exchanges, gifts and transfer of actionable claims. The most interesting question to be discussed is whether the Transfer of Property Act is far-reaching or extensive. The answer to this question is the Act does not deal with all kinds of transfer. The Act is concerned with voluntary transfer and transfer inter vivas. What is meant by voluntary transfer? There is a distinction between voluntary transfer and compulsory transfer. For example, when a person becomes insolvent, his property rests with the official receiver. This process takes place by operation of law, which is not the concern of Transfer of Property Act. Voluntary transfer means transfers entered by the parties on their own accord. It does not deal with compulsory transfer. Second, transfer of inter vivas, that is, transfer made between living persons, is covered by Transfer of Property Act. This precludes from the purview of the Act testamentary transfers and also succession to property by way of inheritance. Let us now move to section 2, where an important question is raised with respect to the territorial nature of Transfer of Property Act. Whether it is a lex loci. A territorial law is a lex loci or a law of a particular place, and it applies to all persons inhabiting the territory irrespective of their personal status. We have to distinguish this with a system of personal law such as Hindu or Mohammedan law. The last part of section 2 says that nothing in the second chapter of the Act that deals with general principles relating to transfer of property shall be deemed to affect any rule of Muhammadan law. Here the construction or interpretation by the court is that we should execute a careful reading of section 2, which would indicate that chapter 2 of the act would not apply to Muhammadans only if there is some rule of personal law in question which is inconsistent with the provisions of chapter 2 of the act. One of the provisions that comes into conflict with the Tranfer of Property Act under Muhammadan law is that a settlement made in perpetuity for the benefit of the descendants of the settlor is a valid work when there is an ultimate gift is given in favor of charity, otherwise called as charitable gift. This rule is quite inconsistent with section 13 and 14 of the Act, but section 2 saves the Muhammadan law. The court has clearly explained in the cases of Durgazi Rao and Hasan Khani Rawtar that there is no rule of Muhammadan law inconsistent with it when construction was made under section 51 of the Tranfer of Property Act and also under section 6. Under Hindu law, a gift could not be made to an unborn person. This rule was applied by the Privy Council in Tagore versus Tagore. A transfer in favor of an unborn person is allowed by section 13 of the Tranfer of Property Act subject to certain conditions. Hindu law has been modified by legislation and gifts to unborn persons are permitted subject to the conditions prescribed by section 13. So there is no rule of Hindu law that is inconsistent with the provisions of chapter 2. So it is clearly established that the Tranfer of Property Act is a territorial law. Next, let us move to the interesting part of Tranfer of Property Act, the interpretation clause pertaining to definition of immovable property. It is quite surprising that we are not provided with a comprehensive definition of immovable property. Section 3 para 2 provides us a negative definition. As it says, immovable property does not include standing timber, growing crops or grass. But we are able to get an inclusive or a working definition in the General Classes Act 1897, which defines immovable property includes land, benefits arising out of land and things attached to the earth. The Tranfer of Property Act supplies us in para 6 of section 3 the meaning for attached to earth. Attached to earth means rooted to the earth. For example, in the case of trees and shrubs. Embedded in the earth, as in the case of walls and buildings. Third category deals with attached to what is so embedded for the permanent beneficial enjoyment of that to which it is attached to. They are called as fixtures. For example, the fans, doors, windows attached with the building comes under this category. An interesting question and a rule has been laid down in the case of Marshall versus Green. The case law is related to deciding with respect to whether a tree has to be treated as a movable or immovable property. A distinction has been made by the court between tree and standing timber. Trees, so long as they are rooted in the earth, they are immovable property, provided they are not standing timber. But what is the test to be applied? It is laid down in Marshall versus Green and Sini Chettiar versus Shantanathan. The real test for judging whether a tree is immovable property or movable property is to consider the way in which it was intended to be dealt with at the time of transfer. If the intention of the parties is to cut the trees immediately and take away, then it has to be treated as movable property, which does not require any registration. But if the intention of the parties is to leave the tree so as to get further nourishment from the soil for further growth in future, then the property will be categorized as immovable property and the formalities of registration to be followed. So this is the short lecture with respect to section 1 to section 3 immovable property. Thank you.